Yeah, and it pained me grievously to look like Mr. Parker all of a sudden, but in any event,
Did you hear us?
Yeah, I don't know if he even heard you.
I knew he wasn't. Is he listening now? There we go.
Go ahead and state your appearances.
Good morning, Your Honor. Eric Pepperman, also on behalf of plaintiffs.
Good morning, Your Honor. Eric Newman.
Good morning.
And good morning, Your Honor. I'm on Zoom. This is Teddy Parker, also on behalf of the plaintiff.
Good morning.
Good morning, Your Honor. Joel Odou on behalf of the rural water defendants.
Good morning, Your Honor. Eric Newman on behalf of defendant Costco Wholesale Corporation.
Okay.
Should
Should we do the easy one?
Yes, that's all. Yeah, I'm here on the motion.
Good morning, Eric Freeman on behalf of Real Water Defendants.
Oh, good morning. Thank you, Mr. Freeman.
And good morning, Your
Anybody
Honor. This is Robert Eisenberg on behalf of the Real Water Defendants.
Okay,
Just observing this morning.
sure. Good morning. Good morning. Anybody else on Zoom before we go on? Okay, no, thank you all. So Costco motion for good faith settlement, is that right?
Yes, sir.
Can we do a quick in camera when you come up quickly?
Can I approach the bench and let you know what the settlement amount was?
And anybody else is welcome to. We're gonna go pause, like don't record even up here. Okay, the court as well as Mr. Odou have both reviewed in camera the settlement amount. Any issues, Mr. Odou?
No issues, Your Honor.
So court also doesn't have any issues, so the motion for good faith settlement granted in its entirety. Prepare an order. The court incorporates all the reasons in the motion, make it detailed, submit it to everybody who wants to see it for review.
Thank you, Your Honor.
Thank you. And you're more than welcome to leave, or if you really want to stick around, that's okay too.
I'm okay.
Okay. Oh, so we're probably gonna have to continue the motion to retax the costs. Cause I had a lot that I didn't get to that, but the other ones I did review. Motion for fees and quote unquote extra cost interest, motion for new trial, alter amend. And I don't have much of a preference, but it might make sense to do defendant's motions first, but
That's what we've done in the other ones, Your Honor,
Okay.
so that probably does make the most sense.
okay. So to give a preview, that I don't got to do, but the 9.99, I'm probably inclined to do that. 120-day stay, that's not objected to, inclined to do that. The remainder of defendants, somebody correct that. Remainder of defendants, I'm inclined to deny. Somebody keeps trying to distract me on Zoom, but that's what I'm inclined to do on those, but welcome arguments.
I'm sorry, Your Honor, I didn't hear the very last thing you said.
Welcome arguments is.
Thank you, Your Honor. We have quite a stack of paper here, so I just want to make sure that I get organized. Well, I think it probably makes the most sense to start with the offsets.
Okay, bear with me, let me turn so the offsets in terms of. Which motion are we talking
So
about?
the motion for new trial, in the motion for new trial, we addressed on page 10 of our motion, the offsets for settlements such as the one we just saw in
Oh,
camera.
right, gotcha, okay.
And I think that's probably, I'm happy to argue the entire motion. Whatever's easiest for the court, I can argue the offsets first or do the whole thing. Whatever makes the most sense. I think the offsets is the least controversial, maybe. What's the
Yeah.
court's pleasure?
No, that's fine.
So I'll argue the offsets, and then if I don't know if plaintiffs wants to argue the whole thing, but I'll argue the offsets, and I can go into the other parts. So, Your Honor, obviously, this is the third case that has gone to trial, just to give the court preview. We have a split decision in judges.
Okay,
And so Judge Williams went with the ratio argument that the plaintiffs proffered. Judge Kishner did not. Judge Kishner applied the offsets to the compensatory damages. And without getting into any of the amounts, because those are confidential, the way we handled it was there was a submission in camera that the parties worked out as to how those offsets would apply. And so whatever the court's ruling is today, certainly the parties can then come up with an in-camera submission and do it that way. So I'm just going to argue in the generalities. Your Honor, obviously, all of the settlements that we're aware of were paid by insurance companies. Typically, insurance companies do not pay for punitive damages. There are certainly parties who had exposure up and over and above possible insurance limits, but it really seemed to us that all the settlements that we are aware of for the co-defendants are for the same injury alleged by the plaintiffs. And so those settlements were paid by insurance companies. It's the same injury. Our client was the manufacturer of the product. These folks were distributors. There's not a whole lot of difference in liability between distributors and wholesalers in terms of the injuries. The injuries ultimately were the liver injuries complained of by the various plaintiffs. And so for that reason, Judge Kishner went with our argument that the offsets apply to the compensatory damages. Now, in certain situations in that case, there were some where the compensatory damages were less than the offsets. And in those cases, the Judge Kishner had ruled, well, the plaintiffs don't have to credit real water for whatever is extra. The offsets would only apply to compensatory damages. And if there's extra, it doesn't carry over to the punitive damages. In Judge Williams' view, he went with the ratio for the arguments basically that the plaintiffs put forward. We think the ratio argument doesn't work. And it doesn't work because we've now tried 3 of these cases and the ratios between punitive damages and compensatory damages are quite different. This one is 32 times. So that's a lot different than Gallagher, which was, I think, I don't remember the ratio, 9 or 10 times. We've got a lot of arguments on the punitive damages. I'm happy to address that when we get to it. But the reality is under the J.E. Johns and Associates versus Lindbergh case, we think that the offset should apply to compensatory damages. I know this issue is presently on appeal in the Chiavani case. I don't believe we have a ruling in the Chiavani case from the Nevada Supreme Court. And so ultimately, this is an issue that will be decided by the Nevada Supreme Court.
so you're saying I should take it under advisement and wait and see?
No, no, we're saying you gotta make a call. The other 2 judges have made a call, ball or strike. We're just looking for this court's call, ball or strike, in terms of, how this court views the issue. And, we go from there. Unfortunately, the Nevada law doesn't seem settled to us. Certainly, Mr. Kemp will make his arguments about how the different judges applied the rule. In this case, he happens to be the attorney in the Chiavani case. I won't even try to speak for him as to the arguments there, but we think it's a straight up issue. Is it the same injury? And we think it is because our client was the manufacturer.
Plaintiffs even concede that, right?
Yeah, I think somewhat. I mean, again, I don't want to speak for plaintiffs.
No, I mean, I'm reading, not quoting that basically players concede. So, but what they argue is that second factor or test, I guess. Yeah.
Where you were looking at theirs.
Oh, yeah, so what you're saying is, we believe it's the same injury, and I said, yeah, plaintiffs agree with that, actually. And what they're arguing, though, is the second part of the Lindbergh test. You know, where they get into the, you know, the block quote there, this is on the brief at page 2. Yeah. Toward the top.
Yeah, the exposure test, Your Honor.
Yeah.
And Your Honor, the exposure test is interesting because that issue came up in the Henderson case before Judge Kishner. And in that case, there was an argument that one of the settling parties had some exposure for discovery violations and getting their answer potentially stricken and that sort of thing. We don't have that in your case, but it was interesting that that argument was made in the Henderson case and not adopted by the court. So again, the exposure test, if we had different fact pattern, it might apply. But in this case, again, the exposure test, the injury, if you will, is the defective product was allegedly sold by these distributors, sold by these manufacturers, sold by our client, and caused the same injury. And so it's the same injury, whether it's an exposure test or not. Certainly, I believe the plaintiffs have arguments about certain distributors such as UNFI, UNFW, whether or not they should have tested the product. And they had argued that the failure to test meant that their exposure was different than real water. The UNFI and UNFW counter argument was the product was sealed. We don't have to, under federal law, open the product and test it. And therefore, their argument was they're not negligent, which is not proper law. But if you accept their argument, the exposure then is still the same. It's still the same injury. And the exposure for a distributor is the same as the exposure for real water, who also distributed their product. So same injury, regardless of which two tests that you go under. Obviously, Lindbergh was, home buyer and seller and real estate agents. That's quite different facts than we have here, where we have strict products liability.
Oh, thank you. Anything, so sticking with, this is part of the motion for new trial, or in the alternative, alter, amend, and remit it or stay. Anything further on the other parts of the motion?
Yeah, Your Honor, I can certainly address the other parts of the motion and would like to do so. First off, what I'd like to mainly focus on is the two different parts. One is the issue that I feel like we possibly have beaten to death. So I'll apologize in advance. But as this court will recall, in pretrial motions and in argument for the admission of evidence, the issue was subsequent, well, it's mostly prior complaints going back to 2014. We argued before the court the Robinson case, which was a box crushing machine without a safety screen. The Beatty case, which I'm going to come back to, the Guinness case, which is an automatic door case, the Andrews case, which is Harley Davidson. And in that particular case, that was a defective gas tank that would not detach in an accident and the person was injured. And the Rheingold case, which is the wet and wild case, which is the water slide.
This
Your Honor, none
might
of these
be.
cases- Sorry.
No, don't apologize to me. I should apologize to you. This is probably when I have to tell you. I've got a lot behind you still,
You're right.
unfortunately, so you might need to shorten time up a bit.
No, and I appreciate that. And our point is this, none of those cases dealt with a medical causation issue. None of them. The Beatty case was a medical product, but there wasn't an issue of causation. And so we're not suggesting that the court as a gatekeeper has to look at the prior complaints and say, oh, well, you know, they've proven to a reasonable degree of medical probability that this injury occurred because of this. No. But the cases, all the cases cited made clear that there has to be a nexus. There has to be some type of substantial similarity between the injury and the prior complaints. And in all of those cases that were cited by the parties, that's visible. You can look at a door, you can look at a motorcycle, you can look at a water slide. Here we have liver injuries. And so because somebody got a bottle of water and said, well, it smelled funny or it tasted funny, the jury was allowed to speculate that was because it had hydrazine in it. And we believe that that evidence was admitted over Will Waters' objection. It should have been excluded and should not have been allowed. And so again, Nevada case law does not, in those particular instances, directly address the issue. We believe it was an issue of first impression for Judge Williams, Judge Kushner, and now for you. And we understand the court's ruling, but all of those customer complaints that were admitted were prejudicial and not probative. And it was impossible for Will Water to go back to 2014 and try and prove a negative, which was, you know, somebody smelled a bottle and it was caused by the bottle plastic formation machine that forms the bottle rather than hydrazine. And so for those reasons, we think those were improperly admitted. As far as the other points of our motion, we had argued that there were claims of the bystanders that were not properly pled. We filed a motion for summary judgment on that. The court denied that. We don't want to waive that argument. We believe that was improperly admitted and that the plaintiffs bystanders were allowed to recover. We pointed out that Jeffrey Dosatel didn't work at the company at the time the product was made. And I'll just wrap this up in a bow. The Jeffrey Dosatel and the NSF audits were improperly admitted, and it was somehow believed or speculated, jury was allowed to speculate that those showed evidence that the water had hydrazine in it, and there was never a causation established for that. In fact, the audits had nothing to do with hydrazine. The audits were allowed in, and the jury was allowed to speculate, and we believe that led to an improper jury award of $94 million. I believe that is all the issues that I wanted to highlight for the court's attention. I recognize I do have people behind me, and there were additional arguments that we made in our motion, and I don't want to waive any of those.
No, they're definitely not waived. Yeah, thank you very much.
Thank you, Your Honor.
Thank you, Your Honor. I'll try to be as quick as possible myself.
Focus on Lindbergh and the offsets, because I'm, you know, in all candor, like Mr. Odou appropriately acknowledged, you know, a lot of those other issues we had extensive briefing arguments on. I'm not inclined to change on any of that. But I think the offset issue is certainly new to me, so.
Yes, sir. Yes, Your Honor. And that's not surprising considering Lindbergh is a fairly new case. But it is very clear. And the issue is stated succinctly as whether NRS 17.2451A requires district courts to automatically deduct the entirety of a settlement award without considering the makeup of the award in relation to the judgment against the non-settling defendants. That's their argument. Don't look at the makeup of the settlements or the exposure, the different exposures that were being settled. Just automatically deduct the entire amount. And that's exactly what Lindbergh says you don't do. You don't automatically deduct the entire amount. You got to look at the exposure. And looking at the exposure, like real water, all of the settling defendants faced exposure to actual damages, i.e. the compensatory damages for the same injury, the physical and general special damages that were awarded as part of the compensatory verdict, and punitive damages, which is exposure beyond actual damages that are unique to that individual defendant. As a practical matter, regardless of what insurance covers, these defendants paid money to settle all the claims against them. They settled their exposure to compensatory damages, and probably more significantly in relation to what they were motivated in the settlement amounts, they settled their exposure to punitive damages. So the task becomes, we have to differentiate those, because we concede some of the exposure that was settled is for the same injury. Some of it was exposure that was settled was for unique injury. How do we apportion that? And we think that the most logical, practical way to do that is to look at the makeup of the award as to real water. It was 1 part compensatory, 9 parts punitive.
Or
So
at least at least if we come down, right, in terms of the ratio.
based on what, Your Honor, I think indicated your inclination, which was based on our agreement. So for our purposes, using that number, assuming that's the number, we think that's the apportionment, and they get the credit for the same injury. They don't get the credit for the exposure to the unique injury. That's exactly what Lindbergh says, and that's how we believe that this issue should be resolved.
Thank you. I'm gonna cut off your rebuttal because what I need to do is take another advisement on the offset issue. I'm just not familiar enough with that. I can see both sides, which might be why one colleague did one thing, one did the other one. The other issues, like I said, I'm not gonna change my mind on those. But yeah, so under advisement overall, but really on the offset and the Lindbergh, and okay, next one is the other motion to alter amend, but this time on punitive damages, or motion for new trial remitted or yeah, this 9.99 to 1 ratio. The one and this is kind of a form over substance, but the one area I think I disagree with plaintiffs on, I don't think they waived their 59 arguments by not filing the 50 motion. But notwithstanding that, I'm inclined to deny the remainder of the motion, other than reducing the punitive damages to the ratio. But punitive 9.99 to 1 would be the compensatory coupled with the interest. But welcome arguments.
Thank you, Your Honor, and I'll just focus on the ratio without waiver to our other arguments, of course. Your Honor, the ratio 1 is kind of interesting because, again, all the cases cited talk about the ratio, not of compensatory damages to punitive damages, but the ratio of the harm to the punitive damages. And so we're concerned that that kind of takes us away from Nevada law, and it's not something proper for consideration. And I understand that the compensatory damages are a yardstick, and certainly some evidence that the court has, but we really think that you need to look at the harm. And so in other words, And why I say that is because several of the punitive damages cases involve nominal damages. Where you have, a nominal injury, but punitive damages were awarded 4 or 5 or, 32 times the amount of compensatory damages because it was a nominal injury. Here we have the opposite. We have a massive punitive damages award. And so when the court, and I'm not picking on the court, but I want to highlight. For the
No,
court,
I am not offended. That's
and I'm not trying to be offensive. I appreciate that, Your Honor. And we've been in front of you enough. We get it. The difference between 9 and 9.99 is about $731 million. So it's a pretty big difference when we're talking about little changes in the award and little changes in the percentages. And we've kind of pointed that out in our reply brief, which was whether the court picks 9 or 9.99 is a big deal when you're talking about a $3 billion verdict. To put that in context, and I have to make this argument because I find it fascinating. If the punitive damages verdict or the attorney's fees will get there, comes out to be $1 billion. That's $83,000 for every attorney in the state of Nevada because we only have 12,000 attorneys. It's a massive number, Your Honor. And it's a massive number because there was an intent to punish Coke, Dasani, and Nestle, and it was not focused on harm real water caused. It was focused on this perceived need to deter Coke, Dasani, and Pepsi from making an alkaline water. And for those reasons, Your Honor, we think the punitive damages verdict was excessive. Clearly, it shocks the conscience when you talk about a $3 billion number. And it was not based on the evidence. And so I would rely again on our pleadings for the other issues that we raised. But, again, whether it's 9 or 9.99 is a really big decision for the court. And so I would point that out. And the verdict was the product of, 32 times compensatory being argued to the jury over our objection. And that's so, I get it. Plaintiffs want to get a big number, but they argued for an unconstitutional verdict under the BMW case. They got an unconstitutional verdict. And now we're asking the court to at least rein in the jury verdict. And with that, Your Honor, again, I appreciate we have limited time today.
And I appreciate your appreciation. Thank you.
Your Honor, I started out by agreeing to take the biggest haircut in the history of Nevada, $2 billion.
Out of the kindness of your heart.
Yeah, and it pained me grievously to look like Mr. Parker all of a sudden. But in any event,
Did you hear us?
Yeah, I don't know if he even heard you.
I knew he wasn't. Is he listening now? There we go. All right. Your
Oh, I'm
Honor,
listening. I am listening.
okay, so it didn't look like he was listening to me. So in any event, 9.99. Let's start out with the denominator. I don't think there's any dispute about it. They had I think 91 million in their brief. When you add the prejudgment interest, it's 104,676,000. We cited the cases in footnote 1 that say that's the appropriate way to do it. They didn't respond to that in the reply. So I just want to make clear that the denominator should be the 104,676 that we've got in there. All right, let's go to the ratio. The Supreme Court has approved a single digit ratio. And I think the important point here is Mr. Odou alluded to the BMW versus Gore case. That was the case where the Alabama lawyer got pissed off at BMW for the paint job they did on his car. And somehow or another, they filed a suit and they convinced an Alabama jury to give them, I think it was 300 to 1. It was a pretty high ratio, and that got cut down. But in that case, and then also in the State Farm case, that was the one that came out of Utah, where they were suing State Farm because the insurance adjusters were systematically cheating the clients when they were evaluating claims. Both of those are business torts. Both of those were punitive claims based upon a business tort. And the Supreme Court went to a lot of pains to distinguish that between a public health and safety case. And the court said that in a public health and safety case, you're entitled to a greater multiplier. And I would submit, we've agreed to the 9.99 to 1, but I would submit that in some cases, we could get a court to probably prove a 12 to 14 in this state. Maybe even in this case we could. But in any event, Your Honor, we're agreeable to the 9.99 to 1. we think that that's the appropriate number. As I pointed out in the motion, they cited the Boykin case against Philip Morris. That was a 9-1 case. So I think Mr. Odou, when he did his closing argument, he was told the jury 4-1, 5-1 would be fine. So 9.99-1 is fine with us. It really doesn't impact things. I think that's all I had. Your Honor.
Why shouldn't I do a 9.49?
Your Honor, because it's a public health and safety case. And like I just said, I would think that I could probably get even a federal circuit court to approve in a public health and safety case like this, where we had over 100.
You have more confidence than I do.
Yeah, well, it depends on the circuit.
That's
But yeah, but in public health and safety case, I think you could probably get it up to, like I already said, 12 or maybe even 14. You know, Judge Posner in that bed bug case that we cited, the Matthias case, he approved, I can't remember what his ratio was. It was 20 or 30 or something. Yeah. But in that case, there was a minimum amount of compensatory damages too. So that was also taken into account. But that was a public health and safety case. And that's where you want the highest. You want punitive damages to deter the most, because we want to protect the public more than we want to protect Alabama lawyers from getting bad paint jobs. So for those reasons, Your Honor, we submit that the ratio of 9.99-1, which is the same thing that Judge Williams did, is the appropriate ratio. Thank you, Your Honor.
Thank you.
Your Honor, a couple things really quickly, just so the record is clear. We believe that the punitive damages was excessive, even if it was 4 or 5-1. We suggested that to try and mitigate our damages to the jury. We were not conceding that the jury should do that. That was argued at one point or another, and I just want to make it clear that we didn't waive our objection to the punitive damages amount or any of them. Your Honor, again, these are the compensatory damages verdict was $94 million. That's nothing to sneeze at. And to argue that, oh, well, we can do 9 times that because it's a public health case, again, disregards the law. The law is the punitive damages have to be a ratio to the harm. And again, yes, the jury returned a very punishing verdict on compensatory damages. And if the jury had awarded 2 or 3 times that, it still would have been a punishing verdict. And it still would have been a verdict that had deterrence to it. So we disagree strongly that there should be some magic mathematical number in a punitive damages case. It doesn't matter at all. The courts in the law is that the damages have to be commensurate with the harm. And this, attempt to put the ratios between a BMW paint job and liver injuries just doesn't work. It's an unworkable formula that the courts are struggling to adopt. There should be no formula. It should be exactly what the law is. And the law is, if it shocks the conscience and it appears to be outrageous, and I know that's a subjective standard, but certainly we have that here in the courts. We're talking about even a 4-to-1 ratio could be constitutionally suspect. This is what 9-to-1 is a lot more than 4-to-1, and 32-to-1 is a lot more as well. And we believe that this award is not only constitutionally suspect, we believe it is constitutionally improper at 9-to-1.
Well, thank you very much. So Judge Williams did 9.49, right?
Your Honor, he did, but the compensatory verdict was smaller. So again, you got to look at the harm versus the number.
So I'm going to change my mind a little bit. So 9.49.
Thank you, Your Honor.
And Mr. Parker.
Yeah, there you
Mr.
go.
Parker's paying for everybody's haircuts out of the court.
And to be clear, so 9.49 to 1, the one that I think the 1.046 million and change number being the denominator there. I think, I mean, both sides' briefs are, super thorough. I think the below the double digit figure is appropriate. I believe that it is constitutional under these facts and circumstances. And so for all the reasons in the opposition, the motion denied, except for I don't think they waived the 59 arguments, incorporate the reasons other than that in the 9.49. So plaintiff's motion for attorney's fees, costs, interest. Declined to grant in part, deny in part, deny, I think. This is an open question. In fact, one that I've had for a while, in terms of, does rejection of an offer of judgment mean that you can get costs in excess of, what the cost statute provides for? And I'll acknowledge, I don't think there's a Nevada Supreme Court case on that point. But I think you read the offer of judgment rule and the cost statute in harmony. So I wouldn't be inclined to award costs, not award a memorandum of costs, which we'll have to come back and argue. But the remainder, I'm inclined to grant. I'll tell you one thing that really stood out to me, not having known, about the offers of judgment. You could probably see me shaking my head because I'm struggling at what words to say. I'm surprised. But obviously they very much should have been accepted as understating it, but so.
Yeah, Judge, I'll be quick. It's undisputed. We made timely offers of judgment. They're far exceeded by the jury verdicts. The total offers were 4.6 million for all the plaintiffs, we just did a good faith settlement that well, I don't want to say too much more of that, but in any event, Your Honor, taking Mr. Morales, for example, the baby Morales, he had permanent liver injury. He's going to have a liver transplant. We offered to sell that case for $475,000. The past and future medical bills that they stipulated to were higher than that. And his compensatory damages were 12.6. So I think it's in our view, it's pretty clear that the reasons that they rejected him were unreasonable. Before getting to those reasons, let's talk about the policy consideration. The policy consideration here is that you want to encourage settlement to preserve judicial resources. That's the policy consideration. And so their suggestion is that we throw that out in the big cases. If there's a big number, we can't do that anymore. I would argue exactly the opposite, that we want to encourage settlement in the big cases because you are preserving more judicial resources. Your Honor knows what it took to get this case prepared. And yeah, we went pretty lickety split in the witnesses, but it still took weeks. All right. So you want to encourage settlement in the big cases as well as the medium and the small cases. So that's why their whole brief, it boils down to two things, which is, the number's too big. And then the second part of their second argument is, we couldn't pay these offers of judgment because we were too busy trying to manipulate the bankruptcy court to accept this $4 million cram down proposal that we came up with, which, as we point out in the brief, that was contrary to Ninth Circuit law. It was just recently rejected by the Supreme Court in the Purdue pharmaceutical case as a technique in bankruptcy. I mean, this was a ridiculous thing that the insurance company was trying to do. They were trying to say, okay, rather than pay our, I think it's 22.5 plus 7, rather than pay out the 30 million, okay, we're going to get the bankruptcy court to buy into this cram down that's never been done before in the Ninth Circuit. And because of that, Your Honor, we couldn't pay any offers of judgment. Well, there's a couple problems with that scenario. First of all, this is their scheme. Okay, they came up with this scheme. They filed this motion with the bankruptcy court. The bankruptcy court rightfully rejected it. But just because an insurance company has a scheme to pay less doesn't mean that that's a reason, a valid reason to reject a reasonable offer of judgment. Otherwise, you would never have an offer of judgment that puts them in jeopardy because they always have some kind of scheme. So that's the first problem with it, Your Honor. The second problem is that this bankruptcy scheme that they imposed, in other cases, we pointed out in Mr. Haley's case and in
They
the Gallagher
accepted
baby case, they did accept offers of judgment. Those were two offers of judgment made prior to the Gallagher case. And they accepted them. And those were rather minimal amounts. One was, they were both $250 and they paid those. Okay. Well, Emily Wren was $250 in this case, the exact same number. They didn't pay that. She went on and got a $6 million verdict. So for whatever reason, this insurance company has just dug its heels in the sand and said, we're not going to pay anybody anything unless the highest court in the land orders us to do so. That's really the situation we're into. And that's not reasonable, Your Honor. But more importantly, that is directly contrary to the policy consideration, which is to encourage settlement. That's not what happened here. So for those reasons, we think the motion should be granted. I don't want to get in, we talked about the Brenzel factors and.
Oh, you could save
Yeah.
for rebuttal.
Okay, thank you.
Thank you, Your Honor. Just really briefly, as an officer of the court, I want to again remind Mr. Kemp, I keep offering to give you guys the checks. You guys have not picked up the checks for the $250.
Yes.
So just.
Oh, I
just
don't even
want
know
there
what
to
we're
be-
talking about.
I just don't want them to have any misunderstanding that we paid, they said we paid the,
They
Gallagher?
pay them, they've gotten pending Mr. Odou's trust account.
Oh,
well, they're checks. I gotta get new ones. So if they want to collect that money, we'll talk about it after court, but
okay.
Yeah.
I don't want there to be confusion on that because I was worried it had been forgotten. I keep reminding them every time.
That's not true.
So, anyways, we'll get that resolved outside of court. Your Honor, the arguments about bad faith, the arguments about the bankruptcy court did this, the bankruptcy court did that. All of those coverage arguments are misplaced. They're not evidence in this case. My law firm, myself, we do not represent the insurance company. We're not in the bankruptcy court. We monitor the pleadings to see what's going on when people get lifts of stay. So we know not to have our client to be in default. But all of that is misplaced. It's outside the context of this case. And so I'm not even going to address those arguments. Those are for other lawyers and other courts, and those are being litigated. I will address, though, the competing claims. There were, at the time of these offers of judgment came in, over 100 claims for the same amount of money, nearly unfortunately, nearly all of probably about 80% of the plaintiffs claim injury in the 2020 timeframe. The plaintiffs in the Gallagher case, same thing as the plaintiffs in this case. I would say the majority of the plaintiffs have injuries in 2020, and there's $1 million primary and $1 million excess, and that is all insurance there is in 2020. Now, I know Mr. Kemp will argue, well, the $1 million primary should be two aggregates, and again, I'm not a coverage lawyer, and I'm not making a coverage argument. I'm merely making an observation that there's limited resources, and at the time these offers of judgment came in, there were probably 87 other plaintiffs who had claims against Real Water, and so it was Real Water's position, not the insurance company, not anybody else, that it could not accept these offers of judgment and have nothing.
But so let me ask though, in
Yeah.
terms of, so when you accept an offer of judgment, that, typically you're gonna pay, but that's not required. You can accept the offer of judgment and say, okay, well, we have no money. Here's the judgment.
And
So,
unfortunately, that was not a decision by my law firm or me. That was a decision made by the bankruptcy trustee and the attorneys, the coverage people. We were told for Real Water, who has no money, my client is Brent and Blaine Jones and Amy Jones, who has no money. And, they would like nothing better than see these cases concluded. But they had no ability to accept these offers of judgment. That was made by other people beyond their control. So I just point that out, and so there's no confusion like Brent, Amy, Blaine, or my law firm or I said, no, we're not going to accept this. We had no ability, we being the client, not me, had no ability to accept these offers of judgment. And there is a interpleader. I don't know the current status of that, but that is going to impact future offer of judgments that have been made. Our only point, Your Honor, is the offers of judgment could not be accepted. They were not accepted. And then as far as the attorney's fees go, again, this is an incredibly large amount of money that we're talking about. Even if we do massage the punitive damage number down to the ratio they're talking about, I think we're still talking about attorney's fees. $500 million or so. And I don't think the Brunzell factors can address something like that, frankly, Your Honor. I think that the Brunzell factors, we're not disputing the quality of the advocacy or, the depositions taken in this and the consolidated cases. I mean, I would note, they say we took 100 depositions. That's in all the cases. But I would note that. But Your Honor, I don't think the Brunzell factors can address something like this. I think that certainly we understand that contingency fees are allowable, but I think that once you get over, I'm just going to call it crazy money. $500 million is crazy money. I think the court has to look a lot closer at the fee and whether the fee is reasonable. And I don't know that the court's got a lot of guidance, but I think this fee is more than too much. And I'll just leave it at that. And again, I'm not trying to be insulting to counsel. They did a wonderful job with these cases.
Thank you.
I think the math is about like 40% to 104 plus 9.5 times 104. That's about, I think it's 440, 430, something like that.
I mean, it's a lot of money.
Yeah, it's a lot of money. I don't know if that makes Mr. Odou feel better, probably not. But yeah, it's a lot of money, but I mean, again, the purpose of this offer of judgment rule is to encourage settlements, and you can't just say, oh, it's a big case, so we're just going to cut it, because then you're not encouraging settlements in a big case. So it serves the purpose of the rule to award the full amount. And then just quickly, Your Honor, he said that they couldn't accept the offer of judgment. They did it in the Haley and Belsky cases. Both of those cases, they accepted the offer of judgment. Maybe it's not Amy Jones's decision, but when we went to the bankruptcy court, we agreed to come over here and pursue just the insurance policies. That was the agreement we cut with the bankruptcy trustee, and that's what we're doing. And so the insurance company is driving the ship here, because Brent Jones filed bankruptcy. Brent and Amy Jones, no one's going to collect a dime from them. So the insurance company is driving the ship. So to suggest that they couldn't pay the money. Yeah, they could have paid the money. They're worth 145 billion. They could pay all these judgments, even if they weren't reduced, if they wanted to. But it's their decision not to, because they're pursuing a litigation strategy over the bankruptcy court to try to minimize the judgments. So far, that strategy has been a complete total failure. Like I said, the bankruptcy courts rejected their attempt to do that cram down, rightfully so. But these are litigation decisions that they made. No one forced them to go to bankruptcy court and try to do this. They could have done what most insurance companies do when they were faced in a mass disaster, which is they pick up the phone, they call the plaintiff's attorney, and they say, hey, we got $50 million in coverage, and we think it's going to cost us $50 million to defend the case. So here's $100 million. You get all the plaintiff's attorneys together. You try to figure out how to resolve this. That's what most reasonable insurance companies do. I mean, I've had that happen many times in my career. But in this one, rather than doing that, they said,
I'm gonna cut you off.
Okay, sorry. Thank you.
No, thank you. So plaintiff's motion for fees, costs, interest, grant, part denied in part as to courts not awarding costs, the outside those costs that the court will be awarding when it decides the motion to retax. The basis for that, I think you read NRCP 68 and NRS chapter 18 in harmony, acknowledging that, maybe we'll get some law that says otherwise from the Supreme Court, but I mean, the briefs were so thorough, I hesitate to say anything further, but for all the reasons, the offers were eminently reasonable. The rejections completely unreasonable in bad faith is set forth in the rule. Policy both, to resolve cases, to save resources, all that supports granting the motion. I mean, I was shocked, probably overstating a little bit, but to see those offers of judgment and as low as they were, shocked to see that those had been rejected. So you'll have to revise the amount, based on the 9.49 ratio. And when do we want to come back for the other?
Your Honor, on the motion to tax costs, if we can come back whenever at the court's convenience. I know the court hasn't reviewed them, and so my question's probably an unfair one, but we were curious if there is a need for oral argument on those. If there's not a need for it, if the court wants to issue those, certainly the defendants don't have an objection to it, but we are also happy to come back, whatever the court's convenience.
And we don't have an objection to having it decided in chambers.
Let's do, thank you both. So let's do this. So I took the one under advisement, and I'll include this one and that as well. On either or both, I might take a look and say, hey, come back,
Perfect, Your Honor. Thank you so much.
But let's do in chambers to give me somewhat more realistic time. January 30th in chambers for the motion to re-tax, as well as the shoot, what was the name of the other one?
Motion for new trial.
Motion for new trial. Thank you. Anything else?
Nothing further, Your Honor. Thank you so much for making the time for us.
Thank you all.
Have a Merry Christmas to you.
Too. Thank you.
Thank you, Your Honor.
Thank you.